Hello.
Oh, hey, just you and me again. Okay, I couldn't see anybody, so.
Yeah.
First District Court of Appeals now in session. All who have business before this court draw near, give attention, and shall be heard. May God save these United States, the great state of Florida, and this honorable court.
Appears we had Judge Lewis and lost him. So since he's chief of the panel, we can wait a minute to get him back on here.
Okay.
Chris is working on it. Just a sec. Judges, David is running up to Judge Lewis's office real quick to see what's happening with the connection.
Okay. Sounds good. Thank you.
Yes, sir.
I think I'm back online now. Can everyone hear me?
Yes.
Okay. Thank you.
I can hear you, Judge. Bill McCabe here.
Thank you.
Yes, sir.
Okay. We have one case scheduled for oral argument this morning, the case of Michael Shelton versus Pasco County Board of County Commissioners. We've allocated 15 minutes per side for the oral argument. Mr. McCabe, would you like to reserve some time for rebuttal?
Yes, Your Honor. I'd like to reserve 3 minutes for rebuttal.
So noted. You may continue.
All right, thanks. May it please the court, my name is Bill McCabe. I represent the claimant, Michael Shelton. Now, in this case, the judge of compensation claims denied the claimant's claim for permanent impairment benefits. He found that claimant didn't have any permanent impairment from this accident, and we submit the JCC erred for a number of reasons. The first reason is we contend the judge erred in striking the opinion of Dr. Borzak, who was the EMA, based on Daubert, because we submit the Daubert objection was untimely. In this particular case, the EMA saw the claimant on July the 14th of 2020. He completed a very extensive 14-page report on July 15th, 2020, which was filed on DOA on August 3rd, 2020. The deposition of the EMA, Dr. Borzak, was taken on September 30th, 2020, And that is the very first time the employer carrier made any indication they were going to raise a Daubert objection. And that wasn't done until they had completed their questioning of Dr. Borzak. And it was a very generic, we're going to object on Daubert. Then the actual motion in limine was not filed until October the 23rd, 2020, just 6 days before the final hearing.
Mr. McKay, what was the date of the final hearing?
The date of the final hearing was October the 29th. And their motion in limine was filed October the 23rd. So we submit that it clearly was not timely filed. So
Can I ask you, since it doesn't seem like you're raising an objection to the sufficiency of the Daubert objection from the depot that was, over a month or 3 weeks or so before the motion in limine. So shouldn't the time start from then as opposed to the motion in limine?
you mean from the time of the deposition?
Right, the deposition, the September 30th deposition, there was the Daubert objection there. Although not particularly specific, as you acknowledged, the specificity isn't raised here. So shouldn't the time be from then as opposed to the motion in limine?
No, because when they made the objection on September 30th, they really didn't say what it was. It was a very generic objection. So the claimant really wasn't aware at that point of specifically what the employer carrier was going to base their Daubert objection on. And it wasn't until the employer carrier filed their actual motion in limine on October 23rd where they spelled out what they were basing their Daubert objection on. So it would seem to me that they should have filed their motion in limine closer to August the 3rd, because Dr. Borzak's report was extremely detailed, and what the employer carrier based their Daubert objection on was all spelled out by Dr. Borzak in his August 3rd, 2020 report. So there was no reason for them to wait until the time of the deposition. They should have filed it before the deposition. They didn't need the deposition to file it.
Counsel, the sufficiency of the Daubert objection is not at issue in this appeal, is it?
Yes, it is. That's my second point, is if the Daubert objection is considered to have been raised timely, I submit the judge erred in granting it anyway, because I don't think Dr. Borzak's opinion is contrary to the Florida guides in this particular case. And I'll get to that. The Florida guides state that ratings of impairment due to hypertension should be delayed until after the drugs have been prescribed and their doses have been adjusted to achieve maximum effect. In other words, you got to wait for MMI. In this particular case.
Counsel, before you get to your second issue, let's backtrack back to the timeliness issue again. Booker is the major case here in terms of timeliness of a Daubert objection. Isn't this case distinguishable from the Booker case on the facts?
Well, I mean, the facts aren't exact, but in the Booker case, this court indicated that the Daubert objection should have been raised. I got the case right here. It should have been raised shortly after, if I'm not mistaken, the let's see. Well, in this case, they say it should have been raised certainly by the time of deposition, but it says it should be raised, if I recall the case, pretty much when the party that wants to raise the objection has sufficient facts in order to raise it. And in this case, that clearly occurred on August the 3rd, not the time of the September 30th deposition. Does that respond to your question, Your Honor?
I believe so, counsel.
I beg your pardon?
I believe so. You may continue.
Okay, thank you. Well, I mean, that's my argument on the timeliness of it. I would like to get to the merits of it too, because bottom line is the permanent impairment rating for hypertension is supposed to occur after the claimant's reached maximum medical improvement when the medication is timely
Let me
taken. into
backtrack to
effect.
the timeliness issue again, though, if I may. Assuming the sufficiency of the Daubert objection is not an issue in this appeal for the sake of argument.
Okay.
And why was the Daubert objection raised at the September 30th, 2020 deposition untimely?
Why was that untimely?
Yes.
Because there's two reasons I'll give you for that. Reason number one is all the information the employer carrier needed for their motion in limine was already spelled out by Dr. Borzak in his 14-page, very detailed and thorough EMA report, which was filed and docketed on August the 3rd. That's number one. And number two, when the objection by the employer carrier was made during Dr. Borzak's September 30 deposition, it was very generic. It wasn't specific. And the Booker case specifically states the Daubert objection has to be specific. It can't just be this general, generic objection, which does not put the opposing party on notice of what the actual objection is based upon. So those are the two reasons, Your Honor. And I guess I'll move again to the merits of the argument because of the objection, because that is one of the issues we've raised. Once MMI was reached in this case, which was on January 30th, 2019, there were only 4 blood pressure readings taken after that date. 2 of them were taken on June 11th, 2019. That was 160 over 100, 170 over 94. 1 was taken on September 11th, 139 over 88. That was Dr. Medina's. And then the other one was taken by Dr. Borzak, the EMA, on July 15th, 2020, 156.90. The only one of those that's below 90 was Dr. Medina's on September 11th, and it was only 2 points below the 90. And that was the basis of why he changed his opinion of the claimant having a permanent impairment rating, because it was just 2 below the 90. The guides require the readings to be in excess of 90, either repeatedly or consistently, depending on whether you're class 1 and 2 or class 3 and 4. But if you take the employer carrier's position in this case, and if you take the judge's ruling in this case, they're reading the guides to say always over 90, because the only one that was below 90 was 1 on September 11th. And interestingly, on that date, Dr. Medina raised the claimant's blood pressure reading of one of the blood pressure amlodipine from 5 to 10 milligrams. And it's also interesting that the claimant's dosage of lisinopril in June of 2019, when Dr. Mathias saw him and he had blood pressure readings of the diastolic of 194, his lisinopril was only 20 mgs. So that was doubled, and Dr. Medina doubles the other medication. The blood pressure reading, the diastolic's only 2 mm's below 90, and yet somehow that knocks this claimant out of having a permanent impairment of his hypertension. So I think it's the judge and Dr. Medina who did not properly read the guides in this instance. Then, I can't see the clock right now, Judge, but if I can go to my third point quickly, the judge in this case also concluded that the claimant's left ventricular LVH, hypertrophy was not compensable, when that wasn't even an issue anymore, and the parties basically stipulated that it was compensable. So number one, the judge shouldn't have ruled that it wasn't compensable when they said it was. And secondly, the EMA, Dr. Borzak, if his opinion on permanent impairment's stricken, his opinion on whether the LVH is compensable should not have been stricken. He was still the EMA, and he opined that the LVH was related to the compensable hypertension. The fourth issue I raised very quickly is that if the entire opinion of the EMA is stricken, then it is our position that the judge should have appointed a new EMA. And the main case I rely on for that is the Falk decision, where the EMA's opinion was stricken because he really didn't render an opinion. And this court remanded it to the JCC to assign a new EMA. And one final thing, and then I'll reserve the rest of my time for rebuttal, is if you reject all of the above arguments that we've made, we still submit the claimant should have a class 1 impairment, which would give a 15% permanent impairment rating, because we again contend that the diastolic was repeatedly above 90 after the claimant reached MMI, and he would fit into class 1 under those conditions if everything else is rejected by this court. Thank you.
And thank you, counsel, for your arguments in this case thus far. Since we had video issues at the start of the OA, I would extend your rebuttal time by an additional 2 minutes and extend counsel for the appellee's time by an additional 2 minutes.
Thank you, Your Honor.
You may proceed, counsel.
Thank you, Your Honor. May it please the court. My name is Warren Sponsler, and I represent Pasco County Board of County Commissioners and Commercial Risk Management. The argument set forth today will show that the judge of compensation claims was correct in his denial of all benefits. I'm sorry, was someone, I heard like something come over the speaker. I wasn't sure if someone else was talking or not.
No, but we can hear you.
Okay, perfect. Sorry, there was some feedback or something. The first issue I'll address is the timeliness issue that was addressed by the appellant. And obviously, the seminal case in this matter is Booker, but Booker actually derived this language from Durling versus Sarasota County Government, which is found at 871 Southern 2nd 303. And as the court in Booker stated, the objection certainly needed to be raised by the time of the deposition. They were actually quoting the Durling court's analysis in that, and Durling basically said the same thing, that the objection needed to be raised at the time of the deposition. In this case, the report was in fact received at some point in time in August, and the deposition took place on September 30th. And I will point out that the report did not contain all of the information that the deposition did. Specifically, the report came to all of these conclusions. And if you and upon reading the report, although it's somewhat confusing, it's even more confusing to determine what the actual basis of those opinions were, which is why the doctor's deposition was taken in the first place.
Well,
and then
the objection in the deposition, though, need to be more specific to be an actual objection. And without the specificity there wasn't truly an objection until the motion in limine 6 days before the hearing.
Well, Judge, I believe that the objection was specifically made, although, again, I do not believe that the specificity issue to the objection is at issue. It was never raised before the judge. And in fact, the judge questioned counsel in detail at the time of the final hearing, and they said the only objection to the dauber was timeliness, not specificity. But I would point out that the only issue in the case was the impairment rating. That's the only issue that mattered in the case. The objection clearly indicated that it was being based upon the fact that there was a lack of scientific evidence and it was based purely on opinion. And that was the only issue in the case. And so I believe it was clearly timely issued. as Judge Almeida found, or timely made as Judge Almeida found at the time of the deposition. And the fact that the motion in limine wasn't done until the deposition transcript was received, et cetera, is really irrelevant. I believe that the motion in limine technically didn't even need to be done. We could have just renewed the objection at the time of the hearing and had it addressed then. And in fact, when the motion in limine was filed, the judge indicated that he really wasn't going to rule on it and he would entertain it at the time of the hearing, which is what happened. So I believe it was timely. And as far as specificity goes, there was no response to that made during the deposition. We certainly could have made it more specific if pressed, but everyone knew in this case, the only issue was the impairment rating. And that was the only issue, and that was the entire basis of his opinion. And the judge found that that it was found timely, and I certainly don't believe that there's sufficient evidence to show that there was an abuse of discretion on the judge's part concerning that.
Counsel, if I could interrupt, could you give us a citation to the record of where in the deposition the objection was made?
I'm sorry, I do not have the citation in front of me, but I know that the objection was made at the end of the questioning.
Okay, was it just a generic one? Objection.
Yeah, it was an objection at the end of the direct examination, indicating that it was being objected to on the basis that it was purely opinion and lacked a scientific basis after the doctor was questioned about how he calculated the impairment rating and what studies he relied on in doing that.
Okay, thank you.
Turning to the issue of the actual impairment rating itself, first of all, it's interesting to me that today appellant concedes that you need to have consistent readings in excess of 90 in order to have an impairment rating. And the reason I find that interesting is because that's the exact opposite of what the opinion was of the EMA physician. In fact, he was asked that multiple times in deposition and gave a statement that the only relevance of that point is that the in excess of 90 refers to rendering a diagnosis, and it doesn't refer to actually the rendering of the impairment rating, which is clearly not consistent with the impairment rating guides. The other point that I believe is important to make is that the impairment ratings that the appellant relies on today are impairment ratings that came after the date of maximum medical improvement, not before. There was a stipulation that the date of maximum medical improvement was January 30th, 2019. And
if I could ask Mr. McCabe, yeah, thank you. Muting it was bouncing, I think, off of him. I think we're good now. Thank you, Mr. McCabe.
Thank you. I thought I was hearing things. Specifically, Florida statutes 440.15 3D indicates that when someone's placed at a point of maximum medical improvement, an impairment rating needs to be assigned. And in fact, the statute goes on to state that an employee's entitlement to impairment benefits begins after the date they reach maximum medical improvement. Well, if someone's entitlement to impairment benefits begins the day after they reach maximum medical improvement, and we know that the date of maximum medical improvement in this case is January 30th, 2019, because it was stipulated to, the diastolic readings after the date of maximum medical improvement are irrelevant. The diastolic readings that are relevant are the ones that lead up to the date of maximum medical improvement and are consistent with what the Florida Impairment Rating Guide states someone is supposed to rely on in doing that. Specifically, the guides say that.
Counsel, I'm not following you there. So you're saying, say he got great, his blood pressure pre-MMI was 120 diastolic, something terrible. And after he got treatment, it was 70, great. You're saying that in that case, there would be an impairment because at one time it was 120, even though after treatment and after MMI, it was well below that?
No, there would not. Our position is there would not be an impairment rating if that happened. In this case, for example, it started out that the diastolic readings in February of 2018 was 165/99. He was then prescribed various medications. By April of 2018, it was 132/82. By the date of MMI of January 2019 that's been stipulated to, it was 130/81. So it's pretty clear that the intent of the guides was met with the treatment that he received. I mean, specifically, the guides state that drugs are now available with side effects that can maintain blood pressure in the normal range in most patients, and that the assignment of an impairment rating or placing one at maximum medical improvement should be delayed until after the drugs have been prescribed and their doses have been adjusted to achieve the maximum effect. In other words, the date of maximum medical improvement. That's exactly what happened here. His blood pressure was clearly above 90. The diastolic readings were clearly above 90. Back in February of 2018, he began treatment with Dr. Medina. Dr. Medina ultimately placed him at a point of maximum medical improvement. The parties agreed of the January 19 date as being the date of MMI, and the rating on that day was 130/81. So clearly, he would not be entitled to an impairment rating. Appellant's argument is that, oh, let's look at the diastolic readings that come in the months after the date of maximum medical improvement, because some of those were above 90. Number one, I don't believe it's appropriate to look at the diastolic readings after the date of MMI, given the fact that the impairment rating has to be assigned at the time someone is put at MMI. But number two, even if you do look at them, in this case, the readings show that on June 11th, 2019, it was 160/100 and 170/94. That was in one single office visit, and it was taken twice. But the record also shows that on that day, he was only being prescribed a 20 milligram dose of lisinopril. Then in September of 2019, the blood pressure was actually, the diastolic reading was only 88. And it was noted at that time in the record that he was being prescribed 40 milligrams. So even if you do look at the dates after the readings after the date of MMI, which we do not believe is appropriate, in this case, when you look at those dates, in the end of the day, it wouldn't make a difference because they still weren't consistently in excess of 90. And I believe,
weren't they at least repeatedly in excess, such that a 15 to 29% impairment should have been given?
well, first of all, Judge, let me just point out that number one, that was never raised at the level below. There was never an issue as to whether the impairment rating below the other class of impairment rating should have been assigned. But number two, the answer to that question, I believe, would be no, because I do not believe that they were repeatedly or consistently in excess of 90 when you look at the actual MMI date. The MMI date from January of 2019, it was 130/81. The April of 2018, it was 137/82. The ones that were in excess of 90 came from February and March of 2018 when he was undergoing treatment and his medications were being adjusted. So we don't believe that they are repeatedly or consistently in excess of 90 as far as the impairment rating is concerned.
So, Counsel, it is your position that none of the blood pressure readings after the MMI date should be considered, even if they are above 90?
Correct, because there's been a stipulation to the date of maximum medical improvement, and the impairment rating has to be determined at the time the date of maximum medical improvement is assigned based on 440/15. Correct. Where the dates after MMI could be relevant is if somebody was challenging the date of MMI. And the argument was, hey, this person's blood pressure wasn't reasonably controlled. It was out of control, and he had to go on another 6 months to a year of medications, and the MMI date should be later. That's never been raised here. There's a stipulation to the MMI date in January of 2019, and that date of maximum medical improvement hasn't been challenged. But specifically with the issue regarding the EMA, he found, again, that you don't need diastolic readings repeatedly or consistently in excess of 90 at the time that the rating is assigned. And that's the specific testimony that the judge rejected in this case, because it clearly didn't follow the intent of the Florida impairment rating guides. And as the doctor testified in his deposition, he found the guides to be inherently confusing, said that the language contained in them was inherently confusing, that the impairment rating guide was logically flawed and not consistent with an understanding of the hypertension or the disease process, that the guide shouldn't be fixed, that the guide shouldn't be static. And everything he said is really an issue for the legislature, not for the court, given the fact that we are required to follow the Florida impairment rating guides. And the impairment rating guides are crystal clear that you have to have diastolic readings consistently in excess of 90 for a class 3 impairment rating. The judge in the case found that he did not have diastolic readings consistently in excess of 90, and there's certainly competent substantial evidence supporting that opinion.
So counsel, assuming we find that the objection was timely made and the judge correctly found that the Daubert, it wasn't Daubert tested, it should not have been rendered by the EMA. Shouldn't a new EMA have been appointed then?
Absolutely not, and I'll tell you why. Well, the first reason was that wasn't raised at the time of hearing.
Well, but his testimony wasn't stricken until the final order after the hearing, right? So I mean, you're supposed to raise something that hasn't happened yet.
Well, at the time of the hearing, the argument was to have the EMA doctor's deposition testimony stricken based on Daubert. Certainly at that time, they could have said to the judge, well, if you do that, we want a new EMA, and it didn't happen. Secondly, there's no provision in the statute for an alternate EMA. The only case cited by the appellants regarding an alternate EMA involved the Falk case, which isn't even applicable to this case. In the Falk case, the EMA physician didn't formulate an opinion. He said he didn't have one and he deferred to somebody else. That's not what happened in this case. In this case, Dr. Borzak clearly rendered an opinion, and his opinion was stricken based on Daubert. And I would also point out, along the lines of the additional EMA, the statute's pretty clear that if an EMA's opinion is rejected based on there being clear and convincing evidence to the contrary, then it's rejected. There's, again, no statutory allowance for an alternate EMA when that happens. And that's exactly what happened in this case. Dr. Borzak had a wrong interpretation of the impairment rating guide. Dr. Medina had a correct interpretation of the impairment rating guide. And this same matter was already addressed by the court in the case of Rodriguez versus Tallahassee Fire Department, which is found at 247 2nd 788. And in that case, the EMA basically said he was incorporating what he called the quote unquote spirit of the guides as opposed to the letter of the word. And that's almost consistent with what Dr. Borzak did in this case, although he essentially rewrote the guides with his own opinion. But the court in Rodriguez clearly stated that the guides, the spirit of the guides, while there can be some leeway given in the interpretation of them, that only applies if a category applicable to the impaired condition cannot be found in the guide. And that's obviously not the case in this matter.
That raises a question of the LVH diagnosis. Why was it appropriate to strike that?
Well, Judge, first of all, I don't believe the LVH diagnosis is even relevant. And the reason I don't believe it was even relevant is because it only comes into play in class 3 as one of the conditions that you have to have if you have diastolic readings consistently in excess of 90. So it never even got to that point. Number 2, there was never a claim for compensability of LDH. And number 3, the judge clearly said at the time of the hearing is the only issue that I'm ruling on is the impairment rating. And the answer that was given was yes, that's the only issue. And so I think the whole issue of the LVH is really an irrelevant finding and doesn't have any bearing. Even if the appellant had LVH, they still wouldn't have an impairment rating because there would not have been readings consistently, diastolic readings consistently in excess of 90. I see my time is.
Yes, counsel, since the JTC struck Dr. Bozek's testimony, then still wasn't there a conflict in the evidence for purposes of appointing an EMA?
Not really. In fact, we had objected to the appointment of the EMA in the first place. And the reason I say not really is because the only evidence in this case about diastolic readings in excess of 90 and what the impairment rating guides say comes from Dr. Medina. If the EMA's opinion isn't there anymore, the only other opinion was Dr. Matthias. He never once mentioned anything about diastolic readings in excess of 90. And actually, I believe the judge articulated his thought process in rejecting his testimony in his order when he talked about the fact that Dr. Matthias indicated required substantial thought, and it was and really nowhere ever talked about the standard, which is the diastolic readings in excess of 90. And I believe that the Rodriguez versus Tallahassee case really addresses the issue that you just brought up, because in the end of the day, the EMA doctor incorrectly interpreted the impairment rating guides.
Thank you.
Thank you.
Ms. McKay, the floor is yours.
Can you hear me, Judge?
Now we can.
Okay. To answer one of the questions, the objection that was made during the
Ms. McCabe, you're cutting out now. We're having problems hearing you.
Your honors, this is Chris Corzine. I'm gonna briefly move Mr. McCabe into the waiting room and readmit him to try to resolve this audio issue.
Thank you.
Stand by for just one moment. Apologize.
Hello, can you hear me?
I believe so. Go ahead.
Okay. The objection made.
We're still having problems. We're still having problems.
You can't hear me?
Are you cutting out on me? Let's see, Chris, can we correct the problem?
Mr. McCabe, I may need you to dial in via the telephone. We're having an audio problem from your location.
I had called on my cell phone. Hello?
We can hear you.
You can?
Yes, we can.
All right, then let me,
We just don't have the video, but we have the audio.
all right, I'll be real quick then, Judge, but the citation, the objection, the Daubert objection in the deposition is found at page 141 of the record. And what counsel for the employer carrier stated was, I am going to, for the record, state a motion to strike the opinions of the doctor based on Daubert lacking a scientific basis and his opinions being purely opinion. That was it. And I would point out that the judge never gives a reason in either at the hearing, the final order, or anywhere why he concluded that the Daubert objection was in fact timely when counsel for claimant was continuously arguing otherwise. Also, it seems to me that the blood pressure readings after MMI would be important in determining whether the claimant has a permanent impairment, since the guides specifically state ratings of impairment due to hypertension should be delayed until after the drugs have been prescribed and their doses have been adjusted to achieve maximum effect. And the EMA felt that that occurred on January the 30th, 2019. That's why that was determined to be the MMI date. And then after that, Dr. Mathias, the IME, saw the claimant in June of 2019, and the blood pressure readings, the diastolic, were both in excess of 90. And then when Dr. Medina sees the claimant in September of 2019, he concludes at that point that just because the claimant's blood pressure diastolic was only 88, he did not have a permanent impairment, even though that doctor thought claimant had a 15% permanent impairment at all times prior thereto. Now, the request for a new EMA was made at the motion for rehearing, which we contend is timely since, as previously indicated, the motion in limine had not even been granted until the final judgment came out. So we think that that was timely.
Assume for the sake of argument that argument is preserved. In rebuttal.
Say one more time.
Assume for the sake of argument that your argument regarding failure to appoint an alternate EMA is preserved for purposes of this appeal. Then in rebuttal, why did the JCC err in failing to appoint an alternate EMA in this case?
Because when the JCC struck this EMA's opinion based on Daubert, the JCC was left without an EMA in this case. And the statute's very clear that when there's a disagreement between healthcare providers as to an issue, an EMA must be appointed. So if the EMA's opinion here is stricken, say we don't have an EMA and another one should be appointed. So that's why we think he erred. And one final thing about the LVH, we feel it's relevant because it's a compensable condition based on this claimant's hypertension. It could become an area that might require special treatment in the future. Who knows? And it was clearly agreed that it was compensable even at the time of the hearing. I believe it's on page 11 of the transcript of the final hearing, where counsel for the employer carrier, when asked if the LVH was still an issue, he says, I don't believe that that is an issue. The pretrial, I think, clearly indicated that the issues resolved were the the hypertension, the intercardiovascular disease from hypertension, which to me would mean the LVH. So
Counsel, I have
anyway,
one question for you. Your time is about to wrap up. Should the JCC have considered the blood pressure readings taken after the MMI date? If so, on what authority?
I believe that they should be considered after the MMI date, and I believe that's because the guidelines specifically state you got to wait until the medications have been prescribed and their doses have been adjusted to achieve maximum effect. That's when you determine what the impairment rating is. That's what the guide says.
Thank you, counsels, for your respective oral arguments. Mr. McCabe, your time has expired. This concludes our oral
All right, we
argument
appreciate it.
for this afternoon.
Thank you so much. Okay, bye.